saying that this was the position that was going to be put to the general meeting, and there was every opportunity for people to organise. And I do come back to what I said. It's bluntly, it's frankly regrettable. We make no bones about that we don't get a greater degree of participation, but it is inclined to be the case that people organise in favour of something that they are strongly in favour of or strongly against. And the position here was essentially that there was a certain section of the profession were very strongly in favour of this, and the rest of the profession were essentially neutral. There has always been on our council and elsewhere, there's always been a minority opinion in the profession that has been opposed to this in absolute principle. We're not seeking to disguise that. We can only say that we test opinion, over a consistent period of time, and all of the evidence that came back to us was that this was the dominant opinion within the legal profession in Scotland.
And in terms of the way that the vote was conducted, in relation to proxies as opposed to an individual postal ballot, as I say, how do you defend criticisms that that's undemocratic?
The reason that we do this in this way is that the annual general meeting of the Society, in terms of our standing orders, has got a variable agenda. If you follow that, there are motions tabled, but amendments can be tabled on the day. And what you're actually voting on, it's very difficult to say in advance quite specifically. This is where we stand on this matter. And so it's been in the Society's constitution since 1949, since the Law Society was created, that we deal with this issue of people being unable to attend an event on the day by proxies. It's very difficult to see, particularly with an issue as complex as this, how you could find a single question that you could put out to a referendum, for want of a better phrase, that would give you a clear result. And we felt, the consultation document that we produced here is a substantial document. It's not a single paragraph proposition. This is a substantial piece of legislation to implement that, and we don't think it was possible to reduce it just as crudely to a yes or no question than that.
Just one final point on this process. You've indicated that you ran a consultation process in order to inform the decision. What research and analysis did you carry out on the proposals on the bill?
Probably best I could maybe give a little bit of background in the consultation first. We had a conference in September 2007 on the future of the legal services in Scotland, and the Cabinet Secretary for Justice was our keynote speaker, and he sort of foreshadowed his response to the OFT's comments on the Which Super complaint, and basically offered, I suppose, the Law Society and I think the Faculty of Advocates as well, the opportunity to, well, first of all, he said status quo is not an option and that restrictions would have to be lifted, but he offered the Law Society the opportunity to come up with proposals for how they could be lifted in the profession's interests. So we drafted a consultation paper, 24 questions long, focusing on all the different models of business structure. It ran for 3 months. We did do an analysis, and the report can be made available, but to give you a brief rundown, we got 92 responses. 28% of those were from 1 to 5 partner firms, 24% of those were for 30-plus firms. And in terms of the responses that we got, I think it's fair to say, obviously, some were for, some were against, and some, I think, thought that it was probably an inevitability. And so really what the outcome was that it didn't really point to one definite course of action, but what people did say was, regardless of what happens, if the legal profession is to be liberalised, then core values must be upheld, independence must be protected, consumer safeguards must be in place. And I think what we took from that, bearing in mind that we were given a mandate to come up with proposals, was that we would try to come up with a policy that could liberalise the legal services market without compromising on robust regulation, but also to offer solicitors who didn't want to opt into the regime, to be able to feel that they were able to continue to practice within a traditional model, and to do that whilst maintaining core values, protecting independence, and that's what our policy paper hopefully represents. That's certainly what the intention was, and that was very much informed by our consultation exercise. But there is a report, and I would be happy to forward that on for anyone who is interested.
Could be done. Cathy Craigie.
Yep, thanks, Convener. Good morning. I think the Law Society is a respected organisation in Scotland, and when the Law Society speaks, people tend to listen to what you have to say. It's disappointing just to hear the responses to the consultation. That, you know, if you've got 10,500 solicitors and 1,200 partnerships or companies, I mean, to get 92 responses is not a very high level. And what I'm interested to find out is just where, prior to 2007, the Law Society were opposed to such a change. So we have a conference in 2007 where the Justice Secretary says, right, this is the only game in town, change or, you know, we'll pass you by. I would like to just know a wee bit more about why the Law Society's opinion changed so much from being outright opposition to agreeing to the general principles as you state in the written submission. So that's, you know, a bit more detail on why. And again, concern that other colleagues have raised, that it would appear, you know, to some of them from the outside, not knowing how the AGM works, it appears as though a big company come in with a carrier bag full of proxy votes and change the opinion. So is that I know that you've tried to answer that this morning, but it hardly seems a transparent and just way to go about representing 10,500 people.
I can only say that, I mean, that is our, just to answer your final question, that is our structure. Every solicitor has the opportunity to cast a proxy vote, to entrust a proxy vote to someone else to vote on their behalf. And that has been the structure that the Society has had since time immemorial. And we find it that there is no perfect way to represent our membership in that sense, because there are geographical issues here as well about, you know, the people from rural Scotland can't realistically be expected to come to one place. You have to meet during the week, and people have, particularly court practitioners, just simply have other commitments during the week. We don't, however, entrust it all to that one kind of big bang. And I mean, I do just want to emphasise the point that Katie made about the consultation exercise that we had gone through. Why did the policy change? The policy changed, I think, really for two reasons. The first reason was because that's what the membership wanted. I mean, I don't think you should underestimate that if our membership had continued to be opposed in principle to ABS, then the democratic will would have carried through in that sense. I mean, you know, I probably wouldn't be here as the president at that point, because I've always been on the other side of the policy argument. But if you have a democratic organisation, then people are entitled to change their view. And I have to say, one of the things, I don't never taken the view that it's an argument that something must happen in Scotland because it's happening in England and Wales, but one of the things was to change the legal environment in England and Wales. Once the Clancy Review and then the Legal Services Act was passed in England and Wales, a lot of our bigger commercial firms saw the danger that the liberalisation of the market in England would allow encroachment into Scotland by the big City of London-based firms, that we had to have the opportunity to compete on a level playing field with them, and that was, ironically enough, only by, if you like, in some ways matching what had been done in England, could we actually preserve the independence of the Scottish legal profession rather than seeing Scottish firms being taken over by the kind of behemoth firms that you get within the Legal 500 in London.
To move on, but there's a couple of points here. Could you encapsulate fairly briefly, Mr Smart, the advantages for the users of legal services as a result of the implementation of this bill?
I've tried to give, you know, a number of examples as we've gone along as to different structures that we might see emerging. I do wish to emphasise, I make no bones about this, that we think this is mainly a matter that's going to be primarily to the interest of commercial users of legal services. But commercial users of legal services are a huge part of the market. You know, we couldn't give you a percentage, but clearly the bigger firms, that's overwhelmingly the sort of work that they are doing, and there is clearly a demand for their client group for that. It wouldn't be hard